Hannah, can we proceed?
Yeah, I think so. So I think the first thing that we'll need to do is appoint a chairman, members. If you'd like to formally appoint a chairman, that'd be great as the first point of action.
I'll propose Councillor Mulligan.
I'll second that.
Thank you.
Thank you, members.
Thanks, everyone. Good morning. First thing we'll do is introduction. So I'm going to ask the members of the committee to introduce themselves first. And I'm Councillor Patrick Mulligan. I represent the Air Valley and Lathersdale Ward, Craven District Council. Robert?
I'm Councillor Robert Ogden, and I represent the Pen-y-ghent Ward.
Chris?
I'm Councillor Chris Morby. I represent Hellyfield and Long Preston, and I'm Vice Chairman of Licensing.
Thank you. And we have our interested party, Councillor Nolan.
Good morning. I'm Councillor Nolan. I represent Skipton North. I've been asked to speak for one of the residents who've submitted their comments.
Thank you. So we have our officers, Hannah Scales, Judith Bramall, who's our legal advisor, and our licensing officer, Tim Chadwick. And could we have the applicant and her representative introduce themselves?
I'm Wendy Graves, going for the personal premises license of Styles Bar, Skipton.
Thank you.
Good morning, Chair. My name is Christopher Grunet. I'm a solicitor representing Miss Greaves in this application.
Thanks. I think I forgot mentioning Vicky Davis, who's with us as well. Okay, so the next step is going to be, excuse me, ask Tim Chadwick to present his report. Tim?
Thank you, Chair. Today's hearing is regarding an application for the grant of a premise licence made by Wendy Greaves for the premise 9 to 11 Court Lane, Skipton. Members are reminded when making a decision that it must be done so with a view of promoting the licensing objectives laid out at point 2. In hearing all the information today, members may choose to grant the licence as applied for, grant with modifications if done with a view of promoting the licence objectives, refuse to specify the named DPS in the application, or reject the application. Members will be aware the premise had the privilege of a premise licence before, known as a ref and whistle. This licence for the premise was revoked by a subcommittee in March 2021. However, members should note this is a new application by a new licence holder and should be considered on the merits of this application. The full application and plans for the application can be found at Appendix B. This covers the intended operating schedule for the premise, such as hours of trading, and the steps that they intend to take to promote the licensing objectives. The application has been subject to a 28-day consultation period. A number of objections have been received and can be seen at Appendix C to J. Due to fear of abuse and backlash to them from the applicant, the objectors have chosen to remain anonymous. This is in part due to malicious online communication received after the review hearing and alleged inappropriate hand gestures made to residents following the review hearing. There are a wide range of concerns within these objections, and the objections are highly detailed. I know members will have read these in great detail and attach the appropriate weight to them, so I won't go over them at this point in time. The concerns raised are regarding public safety, prevention of crime disorder, and public nuisance. Members, you should note when considering public nuisance, it should be considered in the widest possible sense. Under point 6 application, the applicant has applied for licensable activities from 11 till 10 o'clock at night for the sale of retail alcohol. They have applied for the premise to be open between 8 o'clock in the morning and to 10:30 daily. Please just note the reference to the following morning is an error. It's 8 till 10:30 daily. The slight discrepancy in those times is in line with council's licensing policy. The applicant has included effectively a 30-minute drinking up time. This drinking up time doesn't exist in the Licensing Act, so they've included that on the application in line with the licensing policy. And the applicant has also included 3 hours additionally at the start of the day where no licensed activities are intended to take place, but depending on the demand, proposes out to carry out a morning cafe style operations, tea, coffees, etc. Appendix K is effectively the operating schedule, which has been completed as part of the application before you today. This outlines the steps and measures the applicant intends to take to promote the licensing objectives, and if a license was granted, would become conditions on a license that the applicant must adhere to. Members of the subcommittee, before making a decision today, you should consider the information in this report, the representations received and representations made in the consultation and today by the applicant, by Councillor Nolan acting as a representative, along with the guidance under section 182 and the council's licensing policy. Please note the reference under recommendations for North Yorkshire Police can be disregarded. No additional conditions were proposed by the police as part of the consultation. Thank you for your time, and if you have any questions, please don't hesitate to ask me.
Thank you, Tim. Can I now go to any members of the committee if you have a question about Tim's report?
No, I think that was quite a very comprehensive report. Thank you very much.
I agree as well. Thank you.
Thank you. Right. I know Councillor Nolan wishes to speak, but I wonder whether we might have the applicants present, if they would have anything to say first before we go to the interested parties. So would you like to say something?
Thank you, Chair. Yes, I would like to take the opportunity to address the committee. It will give us an opportunity to perhaps address some of the points raised in representations, and Councillor Nolan will obviously note those and have an opportunity, therefore, to respond when he comes back on that. I think that's the correct way to deal with it. This is an application by Wendy Graves, and she is proposed to be the premises licence holder and designated premises supervisor. Before submitting the application, Wendy completed her award for personal licence holders and has achieved her personal licence, so is properly qualified in the terms of the Licensing Act to hold that position at this site. That work by Ms Greaves was undertaken before the application was submitted, so that everything was in place and ready for this committee to be considered. The application is for a premises. I would describe it as a modest sized premises at 9 to 11 Court Lane, Skipton. The venue itself has about 60 for about 30 persons in total at full capacity. The premises is rarely at 100%, like many premises, but at its full go, it's 30 persons or thereabouts. Mr Chadwick has outlined the hours and given a description of what those were for. And that is correct to say that in the mornings, depending on demand from the people of Skipton, if a breakfast coffee bar service can be successful, we would like to explore that in the earlier parts of the day. In the evening and afternoon, the premises will be focusing on craft ales and kind of connoisseur or geeky beer that is of high quality, of artisan nature and provision. Of course, as part of the offer, there will be more standard, perhaps, offers that you could enjoy. But the aim of the premises, and its attempt to be unique, although as soon as I say that, I appreciate it's not unique, but it's to be a cask ale type premises and offer those drinks. There is no substantial food to be proposed at the premises. The kitchen facilities are insufficient for that purpose. Like any business, the cost of food production is quite high, and unless there is a clear demand for that from the community for those sort of items, it can be quite a big loss leader. Our interpretation of our business offer and the clientele that we expect, it is not substantial food of any nature. Of course, drink and beer itself is food, and therefore a food registration form has been submitted more than 28 days before opening to register the premises for EHO inspections in due course. That is the modest application before you. But obviously there's an elephant in the room that we have to address, which is unusual in licensing applications. It's unusual, obviously, that the premises has previously had a premises license and that has been revoked. So although this is not a rehearing of the review, and as Mr. Chadwick has pointed out, and I'm sure the committee are aware, each application will be considered on its own merits. It would be remiss not to talk about the review in some brief detail. May I start by saying what follows does not seek to circumvent or go behind the decision of the committee or the reasons why that decision was taken in March. We have carefully considered the reasons given by the committee in March. This was a result of a review application issued in January at the height of the winter peak, and we are not through the battle of COVID, but we are in a very much different place, and the rules and regulations surrounding licensed premises are very different. So what will follow is not an attempt to minimise the criticism for the committee or its decision. The principal decisions making up a large portion of the reasons were around the COVID breaches, and at that time that was obviously a very critical issue, and the criticism received by Simon Greaves, who was the then premises licence holder in DPS, about the actions and the lack of control or perceived control at premises have been taken on board fully. The issues of noise nuisance raised by residents and disturbance were raised at that committee. Although I was not representing Mr. and Mrs. Greaves at that hearing, the benefit, if I can say, of these formats of hearings is I can watch you all on YouTube and watch in detail what went on at the last hearing and listen for myself about the issues that were raised. And many of those issues are highlighted again as matters of concern for the residents. Noise nuisance, although it was raised and it is mentioned in the review and the decision, my reading of the hearing, of the notice and also the watching the YouTube replay, is that COVID played a very, very significant part of that and those issues. As I say, we're not seeking to defend or minimise those criticisms. Of course, Wendy Graves has made clear in the application it is the wife of Mr. Greaves. She personally does not feature in the decision of the committee in March. She was not wholly not present during the COVID trading periods. Through her own concerns, her involvement in the premises was principally thoroughly cleaning the premises before it started trading in the day, but was not involved in the day-to-day operations at that time. Her only attendance of note at the premises was a meeting with Mr. Chadwick and his colleagues in connection with a prohibition notice which was served in December. Obviously, Wendy Graves, and this is obvious, is a distinct person and a person in her own right. But she is cognizant of the decision of the committee, and she recognises the complaints that have been lodged by residents and others regarding the former action. And those have been taken into account to a large extent, as fully as we can in the application, in part with the timing of the application, obviously following the relaxation of COVID restrictions in licensed premises having been lifted. So this was always intended to come into force after those measures were there. The hours that we propose in this application, with a 10 p.m. Last orders, 10:30 clear, compared to midnight last orders and midnight 30 clear that was under the previous operation. And we've also attempted to address some of the issues and concerns of the residents by condition. This committee will appreciate that a condition on the licence is a very serious matter and must be adhered to. And I'm sure that if we were pulled before the committee for breach of condition, that would be looked at in a very dim light. Some of the conditions that we have tended to try and address residents' concerns regarding CCTV, for example, it is a requirement that CCTV be operational whenever the premises open. And therefore, if the CCTV system is not working, the premises cannot reopen until that is mended, meaning that the operation and conduct of the venue will be under constant recording. We have indicated a risk assessment for door supervisors, appreciating on certain days, even although not every day is the same. For example, there was a period last year where Leeds United were promoted to the Premier League, and there was a lot of celebrations, and it's right for premises to anticipate that that might change the clientele, be more effervescent to require matters. That would be an example of where a door supervisor may be appropriate. We hope day-to-day standard operation that it will not be a effervescent premises which is high energy and causing issue. We accept fully criticism of placing items on the highway. Mrs. Greaves is fully cognizant that placing of A boards, etc. on the highway requires highways permission, and without such they cannot be placed. There's no plans for such A boards going forward. People congregating outside with drinks in their hands, carrying on conversations, and perhaps later in the evening causing a disturbance or raising the background level. We've attempted to address that. In your report at page 27, I would draw your attentions particularly to conditions 10, 11 and 11 of section B, which means that alcohol in open containers will not be permitted to be taken off the premises. So if somebody is standing outside with a glass of beer, acting as quiet as a church mouse, that will be no different, and that will be simply a breach of the licence condition. That the consequence of that, including sanction from the licensing authority, could be a criminal prosecution and a substantial fine. We would like to retain an ability for off sales, but they would be limited to sealed containers taken home, so a carry out for people to take home. We think that's quite a modest part of our business, but certainly the consumption externally would not be permitted. We've also inserted a condition at 12 on the same page that the sale of alcohol will only take place when there is a personal licence holder present at the venue. As the committee will be aware, in order to sell alcohol, you need to be a personal licence holder or authorised by, and therefore there could be periods of times where pubs in your district, without issue, trade without a personal licence holder being physically present. We are stating that if there is not a personal licence holder present on the premises, overseeing the conduct of the licence and the delivery of alcohol, that sales simply will not take place. We hope that this will also give some confidence to the committee and to the residents. Primarily, however, between the premises and the residents, there has been a fundamental breakdown of trust, and the premises must accept its responsibility for that. And what we are going to ask the committee to do is to grant this licence or to allow the premises to rebuild that reputation at the premises. Part of that will involve open and free channels of communication, which are respectful on both sides entirely of each other, to allow issues to be raised and dealt with without the need for or delay, perhaps, of intervention from your licensing authority. We want a situation where, if there is an area of concern, that it can be raised quickly and be dealt with. Obviously, having said that, if we then fail to meet those reasonable requests, I, as an experienced licensing lawyer, having appeared before many committees and listened to many residents bitterly complain about how their concerns, reasonable concerns, weren't listened to, I've advised my client as how committees see that, which is obviously in a very, very dim light. As I say, Wendy is fully cognizant of the previous decision, and her operational input under the previous was very limited. She has made the application on the basis that it will be her business and that she will be entirely responsible for its operation day to day. She fully accepts that responsibility, but appreciates the weight that is carried. She goes forward with her eyes wide open. I am going to ask Wendy to address the committee in a moment, because I think obviously it's important for Wendy to be heard, and for not to give the impression that she is sitting behind a lawyer, and I want her to give you a full view of it. Some of the other issues in the representations that I'd like to briefly address for the benefit of Mr. Noland and the committee. First of all, I would point out that no other responsible authority has commented on the application. And as the committee knows, for the national guidance, paragraphs 9.12, which leads you to say that your responsible authority should be your lead authority on certain issues, crime, disorder, public nuisance, etc. And also 9.15, which I think when you read it through, and I think this is the position, is to suggest that the silence of those authorities should have some weight, that you would expect them to engage in review. And obviously at the review on the last occasion, your environmental health services fully engaged with that and passed comment. The issues about COVID regulation and compliance, at this moment in time, the operation of the premise is subject to government guidance and guidance about maintaining a track and trace system, about considering whether social distancing, one-way systems, table service are all matters that should be considered under a premises risk assessment. And Ms. Graves is intending to fully complete that should the licence be reinstated. If restrictions of the type we experienced over the summer last year and winter are reinstated, Ms. Graves accepts she has two simple choices to make. One, fully and completely implement those restrictions, absolutely, or not operate the premises. They will be her two choices. Unfortunately, the way that the restrictions may or may not be imposed or have been imposed in the past, they don't take account of every different type of premises. How could they? That would be an impossible task. Therefore, on occasion, certain restrictions like substantial food provision, which was a restriction at one stage being associated with food, is not something the premises could do, and therefore that would effectively close the premises. Ms. Greaves accepts that fully and understands that. In respect to the external area, I've covered that already and I won't repeat that, but we are limiting and restricting the consumption of alcohol at the premise to indoors only. The pavement, from my viewing of the site, is not capable of sustaining a tables and chairs licence. We have no application for it. If in the future an application would be submitted, as I stress, we are not intending to do so, it would be fully considered, and I would rate its chances of success due to the narrowness of the path to be very, very low. So we don't intend to do so, and I don't believe that it's a reasonable expectation to happen. Dispersal from the premises. My client is aware of paragraph 2.15 of the national guidance, which talks about the sphere of influence of the premises, that their influence and their responsibilities do not finish at the front door, that their customers dispersing from their venue at the end of the evening is a responsibility for them to control and to consider. And that is a simple fact. And Ms. Greaves wants to make it clear, and will make clear, I hope, that she fully accepts that. Obviously, where that curtilage ends is a matter of fact in each case. I'm sure the committee would not be expected to follow customers home, but you know, a reasonable control is there.
I'm sorry, Mr.
Yes.
Can you draw to a conclusion now? I
can. Thank you, Chair. I I can stay with hand on heart. I am summing up now. Thank you, though, for that indulgence. We would point out that we are drawing forward the potential terminal hour for dispersal from midnight to 10 p.m. That will obviously have a beneficial effect. Some of the residents in their representations are outright opposing, which is their position. Some suggest 9 o'clock would be maybe more appropriate. Obviously, these are things for the committee to consider. In respect of music and live music at the premises, which is an issue raised, we have not sought to apply for any regulated entertainment at the site. However, we are well aware that the Live Music Act and deregulation would allow recording live music automatically to take place. It would be disingenuous of myself to offer conditions to the committee limiting or restricting that behaviour because they're simply unenforceable. And to say to the committee, these are conditions, knowing that those conditions can't be applied, it is seen to be very disingenuous. For the benefit of the committee, we have a detailed noise management plan at the premises dealing with all aspects, deliveries, hours of operations, equipment and music, and it is our intention to fully comply with that. In terms of live music, and common sense would suggest that this would have to be quite modest in the size of venue, otherwise it would be unpleasant. We're looking at a maximum of 1 or 2 events in the afternoons per month. That is our indication. We could have offered that as a condition, but on the basis it's unenforceable. And I'm sure Mr. Chadwick would correct and point that out, as would your legal advisor. It is the reason why we haven't offered it. Finally, if I can, with your permission, ask Ms. Wendy Graves to address the committee now briefly. I know how long she's going to take. It won't be more than a few moments, and then we would rest our case and obviously make available for some questions.
Yes, that's fine. We can go to Mrs. Greaves now.
Wendy, would you mind turning your microphone on? And I think you did have a statement prepared that you'd want to immerse, but make sure you turn your microphone on first.
Can you hear me? Oh, good morning. My name is Wendy Graves and I am the applicant for the new licence. My husband is Simon Graves, the former licence holder and DPS. Following the review application in March, my husband and I have reflected carefully on the committee's decision and reasons. The review application centred around breaches of COVID regulations and noise nuisance. During the pandemic, my role at the premises was limited to out-of-hours cleaning. I was not present at the site while trading was taking place. I do not therefore accept allegations that I was personally wandering around the premises serving customers without a face mask. I did not work at the venue during this period, save in a capacity of cleaning the premises thoroughly each day. I certainly was not involved in the day-to-day running of the premises during these times. Simon's failure to comply fully inexcusable, and I do not seek to defend him in this respect. If approved, sensible precautions to prevent the spread of COVID will be implemented. However, the regular regime is now very much lighter and less perspective. In respect of noise issues at site, I can only apologise if these have been the source of nuisance to our neighbours. The application I've submitted reflects a more modest licence hours and is not intended to attract late night revellers or migration of customers from one venue to another as part of this circuit. I know that in some of these representations, the addition of a well-run premises would add to the amenity of the area, given the opportunity that this, what I shall deliver. The consequences of failure is very clear to me. Before submitting the application, I undertook the necessary training to secure a personal licence of my own. I felt it was important to increase my knowledge of licensing objectives before undertaking this licence application. I appreciate the importance of those objectives and the responsibilities of being a licensee. In the immediate aftermath of the decision to revoke the former licence, Simon and I were despondent and upset. Although not a matter for the committee, the emotional and financial stress has been enormous. I accept, however, that we were responsible for this, although I did consider abandoning the site altogether, and financially this may have been prudent. Instead, I decided to listen to the issues of concern and try and address them through an amending operating plan. Simon's tenure as DPS ended in the revocation of the licence, which is the source of great embarrassment and regret. We recognise that he has lost the trust of the residents and committee and should step back from any prominent role in this business. As premises licensee and designated premises supervisor, I will have the responsibility to ensure the business is operated properly and willingly accept this responsibility. I intend to exercise day-to-day control over the premises. Simon is an experienced plumber and during lockdown returned to his profession to support our family. He will continue to work as a plumber. Historically, I have not been involved in the day-to-day operation of the venue. In the representations, there are several allegations regarding previous conduct. One suggests that I purposely rouse customers to sing and cause a noise nuisance outside the venue. I was very rarely at the venue in the evening and never encouraged customers to cause a nuisance. A second allegation is that I personally made a vulgar gesture towards a neighbouring building. I deny that I have ever done such a thing. A final allegation which I accepted concerns the posting of a notice at site. Following the revocation, I sincerely apologise for the sentiment of this notice and any anxiety this may have caused. This notice, which was posted for a few days immediately following the earlier decision, was wrong. It was an emotional response. Within a day or so, I removed the notice of my own accord, recognising that the notice was entirely inappropriate. I would ask the committee and residents to recognise that I am a distinct individual from my husband Simon and recognise that my determination to rebuild relationships and operate the venue as an asset that Skipton deserves. Although I would like to move forward, I think it's only right that my final words are an apology for any nuisance that may have arisen from the premises in the past. And I am sincerely sorry for any upset this may have caused to the residents. Thank you.
Thank you. All right. Thank you very much. I think what we'll do now is I'm going to come to Councillor Nolan for his statement, and then we will, if members of the committee have any questions for the applicants, we'll do that. So, Councillor Nolan.
Thank you. Good morning. I hope you can hear me clearly. I won't speak for long, I promise you. You've got all the submissions from various residents there. I've been asked to speak by one particular pair of residents of Providence Quarter, but I've had a lot of communication with other residents too. And there seems to be a mixture of great frustration, mixture of anger, and also a cynicism about the process, although given the strong decision that the licence committee took before, I think I'd like them to have more confidence in you, the decision you might make today, whichever way that is. I'll leave that up to you. I accept Wendy Graves' statement. I think, speaking as the council, it might have been good moving before setting this up or making an application to maybe request to meet with the residents, particularly Providence Quarter, and just have an open discussion with them, perhaps say, look, I am his wife, but I'd like to make the business work for me for financial reasons, for personal reasons, for Skipton, and that might have been the best way forward. But I think we're past that. I wonder, I'm trying to speak to the submission that I've been passed by the residents. I wonder, overall, is this a suitable site for this? I mean, there are plenty of other good ones in town. I mean, originally the bar was going to be, as Wendy Graves spoke today and her solicitor said, a discerning microbar of more expensive beers where boring, typically middle-aged man like myself would sit there and talk rubbish and drink beer, as I do in the narrowboat, in the beer engine and others. So you would find me at these sorts of premises in Skipton. I live in Skipton and I enjoy them. So another microbar would be right up my street, so to speak. Actually, it's around the corner, but anyway. So I've no objection at all to this bar in itself, and I think some of the residents have spoken up in favour of the bar. Some have even said we'd love the bar to be working to its original remit, as Wendy said again today. As I said, the discerning real ale drinker who's prepared to pay a little bit more for somebody to bring a range of beers to the bar and all the rest of it. It's just the noise disruption that's caused. I think the proximity to the residential area is a problem. And as Wendy and the solicitor have pointed out, there's been a huge breakdown of trust between herself and obviously being Mr. Greaves' wife. That's a massive problem. The residents have been very active on social media and have noticed Mrs. Greaves present in quite a few photos. So she has been present when the previous customers described as effervescent. Mr. Gruner, she described as effervescent. I think that's one description we could use. They really haven't. They've not behaved as they should have done, which led to the rescinding of the license originally. Mrs. Greaves has made various comments on social media, and they're all for the record. And residents have seen those, and so naturally they're not confident in Mrs. Greaves as whether she will be the license holder that she says she will be. So they wonder whether she will be the most suitable person to run this business. Just a couple more points to make. I agree. It is with the residents that say it seems to be an attempt to circumvent the process. Now, if a new license holder had applied for it, that might have been different, and the residents might have looked at it in a fresh light. But I think Wendy Greaves' connection to her husband is too strong for many of the residents who've had to put up with an awful lot of nuisance, a lot of arguments, a lot of noise, a lot of disruption to the street. There is no outside space. If people go out to smoke, they're on the pavement. It's a very narrow pavement, and it's very difficult for pedestrians to walk past. And particularly recently with the closure of the high street, which I've strongly supported, it's a very well-used thoroughfare for vehicles now. Now that unfortunately is going to end at Christmas, but it is a much busier street now. So I'll leave it up to the committee to decide, but hopefully I've got those points over from the residents, which are all in writing, but I wanted to highlight the main ones that the residents that have communicated with me, they are concerned about whether Mrs. Greaves is the most suitable person to be running this business. And I'll leave it with you. Thank you.
Thank you, Councillor Nolan. So I think the next thing will be for if there are any members of the committee who have any questions for the applicant and her representative. So I'll go to the Councillor Ogden, Councillor Morby.
Yes, would I be able to ask a question, please, Councillor Mulligan? We've heard multiple times from the applicant and her representative that there was very minimal involvement from the applicant in the previous establishment. A general question to start with then, what sort of experience do you have with running a licensed premises such as this that made you want to make this application in the first place?
Well, Councillor, I'm going to ask Wendy just to talk about why she wants to run the business. But as you'll appreciate, Councillor Ogden, she holds the relevant qualification, a training process. There's numerous businesses that one can open without a qualification. And this is one of the few that has that requirement in it. Wendy, do you want to speak a little bit about the type of business and why you think you're appropriate to operate it? You need to obviously unmute when you do that.
Sorry, what was the question again?
Sorry, Councillor Ogden was just asking about your relevant experience. He's heard in the presentation that your day-to-day experience of operations, when it was the previous, was limited. He's just like you to talk a bit about your experience and your, I suppose your experience. I won't change that Councillor Ogden's question.
Yeah. Well, previously we ran a pub in Clayton for 8 years. Obviously, it wasn't my licence, but it was Simon's licence. He had the licence for that public house. We ran the pub. I did the day-to-day duties alongside Simon or staff. We had pool teams. We did food for the pool teams 3-4 times a week. I was a big part in I played a big part in running the pub. Also, when we moved to Skipton, because we gave notice on the pub where we came from. We'd been there 8 years. We gave notice. Obviously, as we was getting a bit older, we wanted a smaller venue, not, you know, big crowds, somewhere smaller, where it would be a lot easier to run, to keep clean, and basically, you know, to get on with people. This is why we moved to Skipton. Skipton's a lovely place, and this is what we wanted to do. Yeah, there has been some problems arose between ourselves and Providence Quarters residents, which we do want to, you know, try meet up and talk all about these problems, what have arose with Simon. We've put a lot of money into the premises. Like I said, we was going to just give it all up, and then I decided to go for the licence because I am good at my job. I'm good at what I do. I get along very well with customers, and it's a job I really enjoy. I'm a people's people. I like talking with people, and this is why I decided to put back in for the licence. So I would run the pub. I'm not Simon. I'm totally different to Simon. I'm a more stronger personality, and I think given the chance, I would be able to run this bar and get along with the neighbours, and that's all I can say.
Thank you for that, Wendy. It's just, you know, it gives a nice broad flavour, underpinning exactly why you this application. Thank you for that. Going down a slightly different route, can I draw people's attention to Appendix I, page 13, of which towards the bottom of that page there appears to be images, several images of 2 different people pouring what appears to be waste beer down a drain outside of the premises. One of those people appears to be the middle of those 5 pictures appears to be the applicant, although the image is not that clear. It is quite a grainy image. I would like to ask Wendy what sorts of precautions she will implement to make sure that this kind of behaviour is not brought to this establishment with this new application.
Can I first and foremost say, I have never poured. That's not me. If there's a lady who comes in the pub who used to clean sometimes if I wasn't available, and the lady looks a lot like me. People get us mixed up all the time, and I'm only presuming she was the one who was pouring down the drain, as Simon did as well. I will not be pouring down the drain outside.
I think that Councillor, that's just to be clear that I appreciate you're not redoing the review. I appreciate that. No defence. We are at no point are we saying that the things that went wrong before were excusable. Of course, that's a very mechanical and clear issue. And proper disposal of waste, food registration forms, matters of that nature, we think are all in hand and will be properly overseen. And you heard what Miss Greaves said about the identity of the person in that picture.
Thank you. The next one, the final one from me, from the top of my head, is on the next page of Appendix I, so page 14, article in the Craven Herald in section 9, showing an image of the applicant behind the bar on that particular image. And whilst the applicant has said that she did not work behind the bar during her involvement with the previous operation, I would just like to draw the attention of committee members to that particular image, which highlights the closeness of the relationship between the husband and wife team, as it says in that.
Councillor, that's not so much of the question as a statement. So I think just to very briefly reply, because it was my initial statement that you responded to, during COVID, my client, Miss Greaves, was not present during COVID. She was not at the premises. So the issues about breaches of COVID is what we're talking about. It was a husband and wife team. She doesn't deny that she's had, but her principal operations was during daytime and not during the COVID period. If I've caused any confusion on that, Councillor, then I do apologise. But that, I think, if you consult the record, is what I was saying. If I was less than clear, I do apologise.
No, I was aware of that, Chris. Thank you for clarifying. My question that I was coming on to was just to absolutely make sure that the applicant is clear on this, that if this application is accepted and passed, will we see a sort of reversal of the roles in this husband and wife team moving forward, or is there going to be a clear separation where Simon is separated from the business in a serving role, which is obviously a concern that a lot of residents have, that it might just after a while revert to what the situation was before. That's my final question there, just to sort of gain clarification for people watching.
I think that's something that Wendy can address with you, Councillor. I would point out again for clarity that we've not proposed a condition that Mr. Greaves will have no role at the venue at all. And we don't want to give the impression that he would never ever be at the venue and that we'd have no involvement. But as the premises licence holder and the DPS, these are specific roles and responsibilities that Wendy is taking fully on board. And that would include for all members of staff or anybody who worked there. Having said that, I think Wendy will explain what her kind of proposed working week would look like. This is not a proposal that the last time Wendy Greaves will stand in this venue is the day it opens and then it will hand back to Simon. That is not at all the impression that we want to give. That is not our intention at all. So Wendy, can you speak a little bit about your kind of day-to-day intended involvement?
Yes. Well, I will be running the venue from morning till evening, 6 days a week. On Sunday, which will be my day off, I will have the lady who works for another establishment in Skipton who is going to come and work on a Sunday so I can have my day off. Obviously, at some point on a weekend, Saturday night, I would like Simon to be there to help me out so that we can combat anybody leaving the premises, keeping noise nuisance down, making sure they're not behaving inappropriately. And I will be running the bar, not Simon. Simon will be doing his plumbing work and just helping me out on a weekend night, Friday, Saturday night, just to make sure to disperse everyone quite in an orderly manner away from the premises.
So thank you very much for those clarifications. It's greatly appreciated.
Thank you.
Thank you, Councillor Ogden. Councillor Morby, do you have any questions?
Yes, yes, I do. I'm just doing a little bit of writing first. Sorry, I don't do shorthand. Right, Simon still holds a personal license, does he?
Yes, Councillor Morby, he does. It hasn't been revoked or any such matter, so he does hold a personal license, yes.
Thank you. Straightforward question and answer, that. I'm rather concerned that Wendy is saying that she'd like to work with the residents, and that is great. That's exactly what we want. But I can't understand why there has been no communication or interaction between Wendy and the residents before this application actually came before this committee. Would you like to explain?
Yes, well, it's a common comment that we hear. Obviously, the purpose of the 28-day consultation period is to engage with residents and to hear their view. We are very aware that relationships broke down in March and it became very polarised, the position. We are content to listen to the representations as they've been put forward and to try and respond fully today. The residents haven't come today. I know that they appeared on the last occasion, that's sort of criticism, but this process itself is a form of consultation and discussion we see. It is a point that Councillor Noland has raised correctly, and yourself, Councillor Morby. We can only extend at this stage an offer to Councillor Noland if he wishes to have a conduit with ourselves and the residents and have a meeting with Miss Greaves and at site to discuss their concerns prior to reopening. Should the committee, we'd be more than happy to undertake that at that stage. We recognised, however, that position become very polarised and that we did not anticipate that residents would turn around and freely allow the premises to apply for an application. We felt that we had to go through this consultation, this process, and then we would have something to discuss around. And we are very happy to have that meetings. And you, obviously, as a licensing committee, can order residents meetings and offers for residents meetings on a regular basis. That would be something we would be happy to engage with if you wanted it to be there. And obviously, we'd be very grateful, I'm sure, for the mediation skills of Councillor Noland, who represents obviously the premises and the residents. He is a representative of business and residents in the area at the same time. So obviously, that ability to mediate and to have those discussions. We sincerely hope that those meetings would be very dull affairs without much to be said, and perhaps become less frequent over time or necessary. But the reason why we didn't go knocking on doors across the road is we appreciated at that stage that the positions were so polarised that this process would hopefully allow us to have make a sensible statement to which residents could react and review and reflect upon. That is the way we've gone forward. If you criticise, you may feel that was the wrong way, but that was our theory behind it. We felt that trying to engage in a conversation prior to setting out the application going forward would have been premature.
Thank you for that. It was more an observation or anything else. I do know that there is in the planning consent that there is a noise management plan in place. The other thing I'd like to draw your attention to is page 4.9.43 at the bottom. It also says we have got to take into account the track record of the business. Okay, so I'd just like to point that out. That's it. Thank you, Chairman.
Thank you, Councillor Morby. Right, I have a question or two, and I just want to pick up on something Councillor Morby mentioned, and that's about this communication issue with the residents. And first, I have a question for Mr. Chadwick, and that is, we have about 9 objections to this application, and only one of which is Councillor Dawson from Skipton Town Council, has put his name forward. Is it unusual to have a number of objections and people wishing to remain anonymous?
Yeah, under the Licensing Act, they've got to provide a name and address to the licensing authority anyway, so we can verify the location and that it's a relevant objection, etc. It's unheard of really for them to remain anonymous throughout the whole process, and there's got to be substantial grounds for it normally.
Thank you.
Councillor Morgan, thank you for that. But, I mean, if I can draw from my experience, I very rarely ever see representations that aren't anonymised, to be honest. I do applications all over the country, and I obviously take umbrage normally at people being anonymised on the basis that it gives an impression to the committee that there is substance behind the grounds. You heard what my client said about some of the allegations in it. She absolutely accepted where she'd gone wrong and not, but we certainly, to express to the committee, the residents should not be in fear of my clients at all. And if they have been in the past, we can only apologise and extend an offer going forward.
Thank you. My other question is about the prohibition of consumption of alcohol off the premises. I think we've seen, you've explained something about that, but I'm not sure I've gotten a lot of details of how you intend to enforce that.
The premises is so small that nobody can exit the premises without being in the sight of management and control. So Ms. Greaves, through her experience in previous premises, signage, education, direction, exactly as it would be in any premises. You'll be able to place your drink on the bar if you wish to go out for a cigarette, and probably be still within sight of it for safety reasons, etc. I'd say it's a modest venue. It isn't a venue where the front door is obscured or away. It's simply management controls. And by offering that condition, we are confident that we can enforce it.
Thank you. So just for complete clarification, my final question is that Mrs. Greaves, during the COVID situation, was not present at the bar and was doing the cleaning, but wasn't doing anything else. Is that correct?
That is our position regarding the lack of control regarding restrictions at the venue, and those criticisms that the committee lodged based on evidence of Mr. Greaves' conduct. As I say, we don't seek to defend that. Wendy, her view of the premises was that the restrictions were difficult to comply with, and that if it had been her operating license and her decision, she doesn't think she would have traded the premises, but perhaps that's going too far. Needless to say, she was not there in the operation day to day.
Thank you. Okay, I think if we just go around to each of us very briefly, not the members of the committee, but the applicant and Mr. Chadwick, and if Councillor Nolan wants to say something, just to have a very brief summary. And we'll start with the applicant.
Very briefly, Councillor Morby, correct that we have to look at, you will look at previous conduct. Obviously, this is a new operator, which I'm sure Councillor Morby will see and give appropriate weight to that distinction. But the revocation of license does not create scorched earth where a premises license cannot be reinstated. Mrs. Greaves is a distinct person. I can understand reservation about the fact that they are husband and wife, but I don't feel anybody or what Ms. Greaves has said today in answer to questions should be the source of concern for the committee, that she is not a firm and distinct person. Nobody suggests this, of course, but it comes to mind if it had been Mrs. Greaves, who'd had a licence revoked, would we be having these concerns about her husband taking over? Would we be concerned about influence in that regard? Mrs. Greaves is aware of your concerns and is confident and has the support of Mr. Greaves, who accepts that he will not be the controlling mind, that she will, and it will be her rules and her management style. When you do look at the application, paragraph 1.17 national guidance, each application has its own merits. Obviously, I think, if I may suggest, that the application, had we not had a review, would be a modest application and be appropriate for both location in terms of hours and activities. Please look at paragraph 9.1215 of the guidance, and please give appropriate weight that crime and disorder is not associated with this premise. Noise nuisance is not evidenced by or supported by the Environmental Health Service. No responsible authority has criticised it. If you would like to add a condition to the licence requiring regular residence meetings or at an interval that you see appropriate, my client would have no objection to that whatsoever, if that's what you would felt would be appropriate to ensure that. And Councillor Nolan, we can obviously have a discussion with him at a later date if he would like to be part of that. My final words are, at no stage are we asking the committee to issue us a licence to allow us to cause crime, disorder, public nuisance, public safety issues, or to endanger children. The licence that you will grant, if you do so, is on the basis that all of those objectives are promoted at all times. That is the proposal. We don't want a licence to cause a little nuisance. The licence that we seek is on the basis that no such action would take place. Thank you very much for your attention today.
Thank you. Councillor Nolan, do you want to make a summation?
Thank you, Councillor Mulligan. It's difficult. I'm not convinced from what I've heard today that the running the bar will be much different from before. I don't think the residents' comments and concerns have really been answered. And the key point that one made is that the residents, and particularly Providence Quarter, was not even mentioned in the residents' application. And I don't think Mrs. Greaves has done any great deal to engage with the residents and deal with concerns from the previous running of the bar. It's obviously up to the committee to decide from everything they've heard today. And I do understand Mrs. Greaves' wish to run the bar and to enjoy running a business that she clearly feels she enjoys. And I understand that. And I think we'd all like to be running businesses we can put our heart and soul in and enjoy running. So I do appreciate that. And if anything, if the bar wanted, if it was to achieve its license, perhaps finishing earlier at 9 p.m. would go some way to assuaging people's concerns that it is, that would be a more suitable time for boring people like myself to have a real ale and then pop off over a hot chocolate. And maybe that's something the bar might consider as offering instead of a 10 o'clock finish, especially with a half an hour drinking up time after that. But I say, looking at the residents' concerns, I don't think they would be convinced, and I'm speaking for them. So I regrettably, that's where I am at the moment. Thank you.
Thank you. And finally, Mr. Chadwick, do you have anything you'd like to say?
Thank you, Chair. I'll just lower my hand. I just wanted to say, Chair, just for some points for consideration with everything is, and some of it's been covered, some of it I'm just touching on again, but really, has it been fully covered how the applicant would work with local residents? How would this work? Councillor Noland has mentioned the preferred approach to approach before the application with the resident. Given the history, how does that trust get rebuilt? And the residents don't live in fear of approaching the premise and the applicant to raise concerns, or even the licensing authority to be able to raise concerns so we can take action if required. Members are aware a premise license, if granted, can at any time be called in for a review. But that does require evidence, and it'd be expected that was substantial evidence. How affected, if there were affected people, how is it to make sure they're comfortable to approach the premise in the first instance to try and resolve issues before coming to the licensing authority to raise concerns? Our licensing policy always encourages dialogue between affected people and a premise, and that's always our preferred approach. I'll just comment, Environment Health obviously haven't made an objection on this for two reasons. One, we're outside of COVID restrictions, so it wouldn't be appropriate for them to make a comment on that, and it's a new applicant. They also wouldn't comment under noise nuisance, because obviously they'd be commenting under statutory nuisance, which has a higher sort of threshold. The objectors have raised public nuisance. Members can consider that in its widest possible sense. The police haven't commented on the application for two parts: extensive operating schedule and conditions offered up by the applicant. And there isn't evidence of crime and disorder from the premise or in and around the premise. In part, it is a new application, so some of that evidence will be lacking, but there wasn't crime and disorder from a police point of view under the old regime. However, that doesn't mean, again, there isn't a potential for public nuisance. A number of the offered conditions were on the last licence held by the premise Ref and Whistle. These couldn't be managed. The same situation, you could view the outside. How would this be different this time round? You know, conditions managing people are always very difficult to control. Members of the public are very hard people to control, especially in drink. So for members to consider how is it different, and how will the steps be taken to address it this time compared to, say, under a previous regime. I briefly touched on this with Mr. Gray yesterday. I take on board Ms. Greaves not being on the premise during COVID, but I was under the impression I had seen her on the premise there, but I don't know what weight I can put to that or not. Other than that, members, you need to take on board everything within the report, what's been said by the agent today, the weight that you can put towards the objectors, Ms. Greaves' submission, and come to a decision. But the decision must be based on a view of promoting the licensing objectives in line with everything you've heard and seen.
Thank you, Mr. Chadwick. So I think we're drawing to a conclusion this first part of the meeting. We're going to, Hannah, I wonder if you might explain the procedures we're going through next.
Yes, absolutely. So we will cease the live stream, go into private session, and a discussion will take place where we will, members will decide with their legal advice, should they need it. Once that happens, the decision will be issued, and then everyone will know what's happening. Chair,
sorry, just
yes.
I was hoping to make my little summary obviously before Chris summarised his. I was just wondering if he wanted to just address any of those, the summary made by myself just before we close, just for.
Okay, you want to say anything, Chris?
Yeah, well, only Mr. Chadwick's. I appreciate he's trying to be helpful, but it obviously is kind of disappointing. I may have seen her at site, but I can't to her saying she's not at site. You know, I think Miss Greaves has a clear recollection. She was the individual. We did meet Mr. Chadwick at site about a prohibition notice. I just wish to make that clear. And I do hear what the Mr. Nolan said about hours and 9 o'clock being more appropriate than 10. We think 10 o'clock is a substantial reduction at a modest hour. Of course, though, if the committee felt 9 o'clock was more appropriate, that would be for the committee to decide. And my client has indicated that they would be grateful for the opportunity to rebuild that trust back with any sort of license. About building that trust, and we think we can't do that effectively until we can put our, to operate and to demonstrate in reality. Again, thank you very much for everybody's input today.
Thank you. Right, so Hannah, is it now just the applicant and the applicant's representative that are leaving the meeting, or?
I'll be
Yeah,
leaving as well.
so just in the meeting, we'll have members and legal, so Tim will leave as well. Yeah, and we'll also go off live if Vicky wouldn't mind doing that. So going into exempt session.
And Hannah, can I just please clarify, you're going to email us the decision in due course?
I'll let Judith reply on that one if that's okay.
Sorry, I don't know whether I'm meant to wait for a decision or
Yeah.
you'll send me a decision.
Normally, I'll get a verbal update after the decision. I'll pass it on to you, and then you'll get obviously the
Fine,
decision
I will
in the
log off
prescribed
and wait for
times.
your call, Mr. Chadwick. Thank you very much. And thank you again, everybody.
Thank you.
Vicky, if you wouldn't mind going off live, thank you very much.